So the first frequently asked questions that we get a lot here as the Parent Training and Information Center is, do I have to sign the IEP? So a parent's signature on an initial IEP, so it's the first IEP that the child has after becoming eligible, allows the school to begin special education and related services. The parent has to give consent for a child to be placed in special education. A parent's signature or parent consent is also needed for an initial evaluation to determine whether or not the child is eligible for special education. Schools generally ask meeting participants to sign only to indicate that they were present as meeting participants. So should a parent refuse to sign an IEP of a child that's currently receiving services, the school would most likely notate on the signature page or the prior written notice that the parent was in attendance but refused to sign the document. So the short answer to this question is the signature for the initial IEP and for permission to evaluate, and a signature is not necessary for an IEP the rest of the time. If the child's already in, your signature is only for attendance. Another frequently asked questions that we get is what if the team doesn't agree? If the IEP team cannot reach an agreement or consensus on an issue or issues, the disagreement should be documented in the prior written notice. Ultimately, if parents and schools disagree in the identification, evaluation, placement, or the provision of a free and appropriate public education, so that's our services and specially designed instruction, the school has the right to make the final decision, and the parent has the right to formal dispute resolution. So that would be mediation, complaint, or due process. And this is where I'd really like to encourage families to call Raising Special Kids if they get to that point to help with problem solving. Another question that we get a lot is from foster parents. What if I'm a foster parent? Do I have the same rights? Foster parents in the eyes of IDEA are considered parents, can and should participate in all decision-making teams. Adoptive parents, legal guardians, individuals acting in the place of parents, so a grandparent or other relative, are all seen as parents in the eyes of IDEA. If a parent in any definition of the term is not found, a surrogate parent appointed by the Department of Education will act in the role of parent at special education meetings. If there's a conflict between a biological parent and a foster parent, the biological parent's input takes priority, assuming that the biological parent's educational rights have not been severed by a judge. So again, IDEA will always look to the biological parent first unless a judge has said, no, that biological parent cannot be involved in this process anymore. Okay. What if my child's not making progress? So at least once a year, a meeting must be scheduled with you to review your child's progress and develop your child's new annual IEP. But you don't have to wait for this annual review. You or any other team member may ask to have your child's IEP reviewed or revised at any time. If you feel your child's not making progress, you may want to request an IEP meeting in writing to review with your child's IEP team the supports, services, and placement of your child. Questions that the team may want to consider are, is the IEP being implemented as planned? So is everybody doing what we all agreed on? Do the goals and or services need to be changed? Okay, do we may need to increase some service time or adjust some goals? Or are there some unusual circumstances affecting the child's performance? So was there perhaps a death in the family that's causing the child to act out? So is it being implemented as planned? Do we need to make some adjustments to goals and services, or are there some outside factors going on? At this point, we have about 15 minutes. We'd like to open it up to questions from the field, and then we'll cut it off in about 10 so that we can finish up our last piece of business. And John, would they need to type their questions?
Yes, they can type their questions right into the chat pod.
Can I request a one-on-one aid with my son's speech therapist. He only received group last time. He is a nonverbal 3-year-old with in the developmental preschool. Okay, so Rochelle, I'm understanding your question as, can you request speech therapy in a one-on-one setting rather than a group setting? Yes, absolutely. You can bring that to the IEP team. He's nonverbal. I'm assuming he may or may not have some supports outside of school, perhaps supports through DDD or Arizona DDD. So what would be helpful for that meeting that you have is perhaps some outside information and data as well to show how he does in a one-on-one setting and the types of progress that he's made. So certainly you can request it. It's still going to be a decision of the IEP team as to whether or not the school will consider it. Okay, good, correct. So yeah, you would want to put in writing something that says, I'd like to request an IEP meeting to discuss speech therapy. My son currently receives therapy in a group setting. I would like to discuss the need for a one-on-one setting with a speech therapist. Follow-up question, what is the normal number of time to request for speech in school? He gets 2 hours a week, outpatient, but only 90 minutes on his IEP. Okay, in school. Okay, so Rochelle, to follow up on that, again, that's going to be a decision of the IEP team on what is appropriate for that child. So the IEP team is tasked with determining what a free and appropriate public education looks like. There is no necessarily minimum or maximum when we're talking about service time. So that decision is made in an IEP setting with your team. Okay, Liz, we're going to go with you. So you mentioned that a parent's signature on the IEP is for attendance. So in the case of the parent who disagrees with the IEP and would like to file a dispute, they should still sign it on the day the IEP is created, and then they would contact Raising Special Kids for support, but still sign it whether you agree or disagree. Yeah, I would sign it that you were in attendance, but be very clear with the IEP team on specifically what your disagreements are, and that you would like those disagreements to be listed in the prior written notice, okay? Prior written notice is where you want your disagreements to be documented. And Liz, I would suggest calling Raising Special Kids before you go into that meeting, not necessarily after you already get into a dispute, because we can help with some proactive techniques in getting you prepared for that meeting. Leslie Williams, if the IEP team is not in agreement in regarding the child's placement, how is the decision made? So ultimately, if it comes down to, and I'm just going to throw in an example here, Leslie, the parent would like the child to be mainstreamed for 3 hours a day, and the school feels that only 1 hour a day is appropriate. Ultimately, if the team cannot come to agreement, it is the final decision of the school has the final decision to implement their program. And then the parents would have the right to mediation, complaint, or due process. Rhonda, what if the recommendations are to change the IEP to a 504 plan? Mm-hmm. Can you disagree? If you want to keep an IEP and not change to a 504, what's the difference? Okay, absolutely. Rhonda, that's a great question. I would absolutely recommend that you give us a call and talk to one of our family support specialists a little bit more about that, but I'm going to give you kind of a generic answer right here. So if a child's currently on an IEP, to be exited from an IEP, you're going to want to make sure that there is some sort of evaluation done. At the very least, a review of existing data that would support the child not needing special education and related services anymore. That would be kind of the least amount that the school would want to do. They could also do a full evaluation with more assessments to show that the child doesn't qualify. Maybe the child still has a medical diagnosis or something else that would allow them to get supports with a 504. Again, in a nutshell, and because we don't have a lot of time, briefly, the difference could be special education and related services means specially designed instruction to meet the needs of the child, whereas a 504 is reasonable accommodation for the child to have access to the general curriculum. So if it's a child that just needs some accommodations and some supports for them to access what everybody else is getting, a 504 could be appropriate. What time do we have now? Okay, 12:53. We give 1 minute for any follow-up questions, and again, certainly encourage anyone to give us a call and speak with one of our family support specialists if you have a specific issue that we need to talk a little bit more in depth about. And thanks everybody for sticking around and listening.